Hello and welcome to Topic 4, Lecture 1. And in this lecture, we're going to be learning about civil liberties. So what are we going to be covering in this lecture? First, we're going to define key terms, civil liberties and civil rights. Next, we're going to look at a brief history of the Bill of Rights. And then we're going to talk about how the Bill of Rights was nationalized to the states. So let's go ahead and get started. So in the next 2 weeks, you're going to be learning about civil liberties and civil rights. And so as you're going to see, chapter 4 that you're going to be reading this week is dedicated to civil liberties. Next week, chapter 5 is dedicated to learning about civil rights. So let's define both of these terms in this lecture. So civil liberties, we've talked about this already earlier in the semester. So in many ways, this is a review. That civil liberties is defined as the individual rights and personal freedoms with which governments are constrained from interfering, okay? And so I think, as I mentioned earlier in the semester, that civil rights are basically telling government what they cannot do. It's kind of a list of thou shall not do these things, okay? And so in telling government what they can't do, it opens up space for people to, to have freedom to do what they want to do with limits. And so, examples of civil liberties are the freedom of speech. So the government is constrained from interfering with free expression. You have the right to remain silent. In other words, government can't force you to talk at your trial. You have the right to be free from unreasonable search and seizure. In other words, government can't engage in an unreasonable search, okay? All of those are examples of civil liberties. And as you know, our civil liberties are found in the Bill of Rights, the first 10 amendments to the Constitution. In Chapter 5, you're going to be learning about civil rights. Civil rights is defined as obligations imposed on government to guarantee equal treatment and to protect citizens from discrimination. In other words, civil rights is about the equal protection of the law, that government must govern in a way that is impartial, okay? And so with civil liberties, we're sort of telling government what they can't do, but with civil rights, we're saying that government has to make sure and guarantee that people are treated equally, right? I guess we're telling government that it cannot engage in discrimination, okay? But we're also, with civil rights, we place a mandate on government to make sure that discrimination is not taking place in the country. And so in Chapter 5, you're going to be learning about the Civil Rights Act of 1964 and also Title IX and other forms of civil rights laws. And when it comes to civil rights, what you'll be learning about is the ways in which people are discriminated in a way or treated partially, right? For reasons that have no merit, right? And so that, in other words, that we might treat people differently on the basis of the color of their skin or on the basis of their sex, right? Or on the basis of their sexual orientation. And as you're going to find in the chapter, we're going to see that some types of different treatment is acceptable by the court, but other kinds are not, and that we have a whole host of federal laws, the Civil Rights Act of 1964 and Title IX, having to do with educational non-discrimination, that we have a whole host of laws that are on the books in order to make sure that people receive equal protection of the law. The reason that we're covering both civil liberties and civil rights in this lecture is because there are times when personal freedoms can come into conflict with making sure that people aren't discriminated against. So that, as it says there, is that civil liberties and civil rights can sometimes come into conflict. In other words, that when a person exercises their personal liberty, whether that's freedom of speech or exercising their religious beliefs, that the exercise of those personal liberties can result in discrimination, either racial discrimination or discrimination based on sex or sexual orientation or gender identity, etc. And so the discussion that you're going to be engaging in this week has to do with that conflict between civil liberties and civil rights. So, can you think of some examples of when civil liberties and civil rights come into conflict with each other? In other words, can you think of some times when somebody's trying to exercise their personal freedoms that it results in some sort of discrimination and some sort of discrimination that the government is supposed to prevent, right? That the government has an obligation from not allowing that discriminatory treatment to take place. So take a moment and sort of think if you can think of a time when these two things come into conflict with each other. So here are two examples of instances in recent history where civil liberties has come into conflict with civil rights. On the left-hand side of the screen, you see the famous Unite the Right rally that took place in Charlottesville, Virginia in 2017. And in that instance, you had neo-Nazis and white supremacists chanting racist and anti-Semitic chants. And on the one hand, that is a freedom of expression. But then on the other hand, does it cross over the line and, engage in any sort of discriminatory treatment? The court would be the ones who decide that. And as you're going to see in this text, in the chapter this week, that the Supreme Court is really quite protective of all sorts of speech that is trying to communicate a political message. So that while somebody might sort of feel as if they are, that this speech is creating discrimination against them or the group that they belong in, that these kinds of rallies of the Ku Klux Klan, et cetera, are generally viewed as protected speech. And so civil liberties kind of is protected over the concerns of the government's responsibility to make sure that people are not discriminated against. Jack Phillips, you'll be learning about him in the discussion for this week. So Jack Phillips, he owns a bakery and called Masterpiece Cake Shop in Colorado. Colorado has laws in the books that prohibits businesses that are open to the public from discriminating on the basis of sexual orientation. And so in this case, a same-sex couple came in. They wanted a cake to be made by Masterpiece Cake Shop, and Jack Phillips refused them service based on his religious beliefs, okay? And so there is another example of that conflict, and you'll learn this week about how the Supreme Court tries to resolve these conflicts. So as we know, the Bill of Rights is the first 10 amendments to the United States Constitution. There are 27 amendments, and the Bill of Rights make up the first 10. And so, you might be wondering, well, why is the Bill of Rights? Why are these amendments? Why aren't these personal freedoms? Why aren't these civil liberties? Why aren't they in the body of the Constitution? Why aren't they in the Article 1 through 7 somewhere? Why did they have to be amended or added as amendments? And the reason for that has to do with the ratification of the United States Constitution. I think I've mentioned this before. As the Constitution was, once it was created, it needed to go to the states for ratification. And as the ratification process started, a lot of the states were looking at all the expanded power that this federal government was going to get under this new constitution, and they started worrying. They were basically saying, wait a second, the federal government has way too much power. Where is protection from that power in the Constitution? How are individuals protected from these new expansive powers of the government? How are states protected from these new expansive powers of the government? And so as the Constitution was being ratified, that state said, look, we're not going to ratify this Constitution until you add a Bill of Rights protecting individuals and states from this expanded power. And ultimately, as we know, that was the compromise that was made. The writers of the Federalist Paper, Alexander Hamilton, John Jay, and James Madison, they were arguing for the ratification of the Constitution. They saw the writing on the wall, and they knew that the Constitution wasn't going to get ratified unless a Bill of Rights was added. And so they made that compromise. But you might be thinking, well, why didn't they add that at the beginning? Why were they sort of not wanting to add a Bill of Rights right from the get-go? And as it says there, one of the reasons why that these are added after the crafting of the main body of the Constitution is because there was a sense among those at some at the Constitutional Convention that you don't need to, as Hamilton says, you don't need to declare. So he said for why declare that things shall not be done, which there is no power to do. And so basically, Hamilton, Madison, they were like, there's nothing in the body of the Constitution that says that Congress can abridge your speech or establish a religion or search you without probable cause. That we haven't given the federal government that power, right? So why do we have to tell the federal government that they don't have that power, right? And there was also a sense if you tell the federal government what it can't do in a Bill of Rights, then it basically limits the Bill of Rights. It says, oh, this is the liberties that you have. And if those liberties aren't in the Bill of Rights, then these are not, liberties that are afforded to the people, right? So, when the compromise was made and when the framers, James Madison, they agree, yes, we'll add these amendments. That was one of the first acts of the first Congress of the United States, was to create the Bill of Rights, and then to present that to Congress, and then Congress voted on it, and then those rights went to the states to be ratified, the Bill of Rights. And it was written by James Madison in 1789. He viewed it as a nauseous project. One, he didn't think it was needed, but also he was really worried that as we were enumerating these rights, what if we leave something out, right? And that it has a really limiting effect on personal liberties. But that being said, it was written in Madison's initial Bill of Rights. There were more rights than the Congress actually approved of, and so out of the amendments, Congress approved 12 of those, and then those 12 amendments went to the states, and the states ratified 10 of those amendments, making up the Bill of Rights. And so it was ratified on December 15th, 1791, and it's been in force ever since. And that's my birthday, see, December 15th, and 1791. What? Yes, that's right. I'm a vampire. No, I wasn't born in 1791, or was I? So how many of the rights in the Bill of Rights do you actually know? Well, for one, I really want to encourage you to read the Bill of Rights. It's in the appendix of your textbook. And it's not long, so at least you can sort of familiarize yourself with some of the key amendments or all of the key amendments, So, there are 5 liberties in the First Amendment. So look those up, see what they are. Second Amendment, pretty familiar with it. The right to bear arms, very controversial amendment. What about the Fourth Amendment? The Fourth Amendment has to do with the rights of personal privacy, in particular, the right to be free from search and seizure from police. It also tells us about how police can search you with a warrant. Eighth Amendment, do you know what that is? The Eighth Amendment is the amendment that prohibits cruel and unusual punishment, okay? And that's just, 4 of the amendments. So make sure that you take a look at and read through the Bill of Rights in preparation for what you're going to be learning about this week. So take a look at table 4.2 in your textbook, because it's a table that provides sort of a really nice breakdown of how to think about the different liberties that are in the Bill of Rights. And so Amendment 1, the First Amendment, is basically telling Congress that it can't do things, right? It's telling Congress that it can't establish religion, it can't abridge your freedom of religious expression, can't abridge your speech, can't tell you that you can't assemble or petition the government for a redress of grievances. So Amendment 1 is focused on congressional power. Amendments 2, 3, and 4 are focused on both the executive branch and the Congress. And it's basically saying that with Amendment 2, the right to bear arms, it's saying that no entity of government at the federal level can impinge upon your right to bear arms, that they can't place soldiers in your home, quarter them in your home for, the purposes of fighting a war. That's Article 3. It's also saying that government cannot search your domicile, right? Cannot search your private places and go through your private things without probable cause. And so those are the amendments kind of telling both Congress and the executive branch that they can't do these things. And then Amendments 5, 6, 7, and 8, those deal with telling the courts that they have to do certain things or that they cannot do certain things, that they can't try you without having a grand jury. That the grand jury is sort of like a a body of jurors who decide whether or not a person should be indicted, right? They don't decide whether you're guilty or not. They decide, hey, yeah, there's enough probable cause here to basically charge this person with a crime. And so the courts can't charge you, can't hold you, try you without having a grand jury. That court must give you a trial jury. Etc. And I'll let you read through the rest of those. Okay. And so these amendments are the ones that deal with basically criminal justice. And then finally, amendments 9 and 10 are the amendments that are placing limits on the national government that open up some space for both the people and the states. We talked about Amendment 10, the Reserved Powers Amendment, in last week's lecture, so that you can review that. Amendment 9 is one of my favorite amendments because it's basically, dealing with Madison's nausea. That basically, that Amendment 9 says that just because a liberty isn't written and enumerated within the Bill of Rights doesn't mean that it is not retained by the people in the states, right? And so the Ninth Amendment is basically saying that there are these implied liberties, right? Just because it's not written down doesn't mean that you don't have those freedoms, okay? So make sure you take a look at that table. It's very useful. All right, the last thing that we're going to talk about in this lecture is nationalizing the Bill of Rights, or how the Bill of Rights gets applied to the states, okay? So, back in my younger days, probably still today too, I teach civil liberties. I'm kind of a civil libertarian, right? But back in the day, before I know what I know today, I was just about freedom of speech, say what you want to say, watch what you want to watch, read what you want to read. And I had a kid kind of young in life, and, I was trying to be the cool mom or whatever. And where we lived, we had this porch in the front. And, I called it the freedom of speech porch, right? And so my son would be like, I can say anything I want on the porch. And I was like, yeah, sure, say anything. And then so kids from the neighborhood would come around and swear and, step on the porch. That's freedom of speech. And then some of the parents wouldn't let their kids come over and play anymore. But also I used to have a sticker of the First Amendment, and I put it on my VCR, if you remember what those are. You put a tape on it and you could play it. And I'm like, hey, government's not going to tell me that I can't watch what I want. But one day, in my silliness and my younger days, I basically saw this word, right, Congress. And, the First Amendment says that Congress shall make no laws respecting an establishment of a religion or prohibiting the free exercise thereof, abridging the freedom of speech, the press, etc. Okay. And I looked at that word and I said, Congress, right? And I lived in Indiana, which is a pretty conservative state at the time. And I was like, oh man, Congress can't make these laws, but can the state of Indiana make these laws? Does the First Amendment only apply to the national government, or does it apply to the states as well? Okay. And so in my younger days, when I was asking that question, like, oh no, I'm gonna get in trouble, right? I thought, I was thinking about this idea of the nationalization of the Bill of Rights, which is basically trying to answer the question about whether or not the Bill of Rights only applies to the actions of the national government, or whether it applies to the actions of the state and local governments as well. So let's look at how the courts answered that question. So the question regarding the nationalization of the Bill of Rights is just quite simple. Given the language of the Bill of Rights, does the Bill of Rights actually apply to the states, or does the Bill of Rights only apply to the actions of the federal government? And so that's the question regarding the nationalization of the Bill of Rights. Does Congress make no laws mean really only Congress and the federal government, or is the Bill of Rights apply to the state and local governments as well? Now, as you learn in your textbook, that until 1868, the court said that the Bill of Rights only applies to the national government, right? And it was determined in the key case, Barron versus Baltimore, which we'll talk about in a second. And so basically, until 1868, that you got a protection from the government, the actions of the federal government. But unless your state had a Bill of Rights that protected you from certain things, then that you basically, were you as an individual, you were governed by two different bills of rights. So let me give you a concrete example, right? And so Congress says the Bill of First Amendment says Congress shall make no law establishing a religion. And so that means that the national government cannot like designate a church of the United States, right? It can't establish a religion. It can't say, Catholicism, that's the national religion. The Bill of Rights prohibits Congress from doing that. But until 1968, that basically they said, nope, that if states want to establish a state religion, right, then unless it's prohibited in their state Bill of Rights, they can do it. And in fact, they did do it, right? And so while we've never had a national religion, that states had their own recognized religions. So for example, the Anglican Church, right, which has now become the Episcopal Church in the United States. That was the state religion of Virginia for a while, right? Maryland Catholicism, right? And that's because there were two different Bills of Rights. Up until 1868, only the Congress couldn't establish a religion, but states could unless their Bill of Rights prohibited them from doing that. This understanding of the Bill of Rights about it only applying to the actions of the national government came through Barron versus Baltimore. It's a great case. It's about Baltimore, which has a water, a bay, right, and that there were people who had ships there, right, and John Barron was one of those people. He had this big ship, and what was really cool about where the water was in Baltimore is that it was really quite deep. It allowed for boats to dock and unload their wares. And John Barron's wharf was the best one in the area, right? It had the deepest level and boats could come in really easily and they didn't have to worry about getting stuck in the mud. Baltimore, decides that they want to improve their streets. And so basically in improving their streets, they throw all of this gravel and dirt and mud into the water around Baltimore. And it ruined John Barron's livelihood. No longer could ships come in and dock there, right? Because it was too shallow now because of all the grit and the gravel being thrown into the water. Well, John Barron sued the city of Baltimore and said that his right to be to eminent domain was guaranteed in the Fifth Amendment of the Bill of Rights. Eminent domain is basically, it's the takings clause. It basically says that if government takes your property from you, they have to give you fair market value for it. And John Barron said, look, Baltimore basically took my livelihood from me, my business, and so they need to compensate me for that. And that question went to the Supreme Court, and the Chief Justice John Marshall said, nope, sorry, Charlie. Too bad, John Barron. He said that if the national government had improved those streets and put that gravel before in your wharf, then you would, the Fifth Amendment's taking clause, eminent domain clause would apply to you. But it doesn't apply to the state of Maryland. It doesn't apply to the city of Baltimore. So unfortunately, you're out of luck unless the state of Maryland and Baltimore, have a takings clause, right? Say that you get fair value of your property, and that was not in their laws. Okay, and so the Fifth Amendment does not apply to the states because it only applies to the national government. That all changes in 1868 with the addition of the 14th Amendment following the Civil War. And in the 14th Amendment is this thing called the Due Process Clause. And it says that states can't take away your life, liberty, or property without due process of law. And basically, the Due Process Clause was the avenue that was used to incorporate the Bill of Rights to the states, okay? Keep in mind, it didn't happen all at once. It was selective incorporation, okay? And so that the Bill of Rights was incorporated liberty by liberty. So on the last slide, I talked about how with the passage of the 14th Amendment and the inclusion of the Due Process Clause, that it was at that point moving forward that the Bill of Rights was applied to the states, right? So that the states had to follow the Bill of Rights as well. And I said that happened selectively. It wasn't like in 1868 with the inclusion of the 14th Amendment that a magic wand was waved and all the liberties of the Bill of Rights immediately applied to the states. That's not what has happened. And in fact, not all the liberties of the Bill of Rights have been applied to the states. The good example is a grand jury, the right to a grand jury. That's never been incorporated to the states. And that's why some states only use a preliminary hearing and not a grand jury. And terms of deciding whether somebody should be charged with a crime. You can take my crime class about if you want to learn more about that, or come to office hours. I'd be happy to talk to you. So check out how long it took, right? So the first liberty to be incorporated was in 1897, and it was the Takings Clause from the Fifth Amendment. This is a case very similar to John Barron's. Didn't have to do with a wharf owner, but it had to do with railroads, right? And that was the first liberty that was incorporated. And then, next in 1925, speech, 1931, press, and some of the criminal justice liberties, such as the right to be free from unwarranted search and seizure, the right to have a jury trial, the right to counsel, okay, here on some of those weren't incorporated to the states until 1960s, the late 1960s, right? And so, that if you were charged of a federal crime, you would get a jury trial and you would have a right to counsel. But if you were charged by the state for a crime, and the vast majority of criminal law comes from states, right? Police powers, reserve powers, it wasn't until the 1970s and beyond where people were getting these really more robust protections of the rights of the criminally accused. And the last liberty to be incorporated, at least on this, is the right to bear arms. And that was incorporated in 2010. So it took a while for that to be incorporated. Sorry that my dog is barking. All right, so as we close out this lecture, I just want you to think critically about incorporation. So as we talked in the last slide, that liberties were selectively incorporated to the states, and it took quite a period of time, and not all the liberties have been incorporated. And that was a decision that the Supreme Court made. They said that, when they decided that some of the Bill of Rights could be incorporated, they said that it needed to go case by case, basically. Well, what do you think about that? Should all of the provisions of the Bill of Rights, they have been applied to the states all at once, like with the inclusion of the Due Process Clause in the 14th Amendment? Or was the selective incorporation the right way to go? What are some of the advantages and disadvantages of selective incorporation? And also maybe think about implications for democracy. What if the Supreme Court said, no, the Due Process Clause doesn't give an avenue for the incorporation of the Bill of Rights to the states? What if the Bill of Rights only applied to the federal actions, not the states, effectively setting up sort of a two charters of liberties scenario? What impact might that have had on democracy, right? I mean, on the one hand, that seems like it's nice to have a unified Bill of Rights that applies to all entities of government, both federal, state, and local. But on the other hand, we depend on the Supreme Court to sort of dictate to us what and what are not our rights. Maybe if we had took our state charters of liberty more seriously, maybe we would work to make sure that state charter of liberty, that state Bill of Rights was robust and provided protections for people living in that state. In a way that we now sort of depend on the federal Bill of Rights, maybe we would depend more and take more seriously a state level Bill of Rights. Just some things to think about. All right, thanks a lot for paying attention, and I'll talk to you again soon.